The Pune police sought custody of the 17-year-old at the remand home and permission to try the accused as an adult. However, the Juvenile Justice Board rejected the application and granted bail to the minor accused on various conditions, including writing an essay and studying traffic safety norms. In this video, we will try and understand if a juvenile can be tried as an adult. So what does the law say on trying a juvenile as an adult? Prior to the 2015 amendment in the original JJ Act, all children below the age of 18 years were treated as juveniles. Now, why was this amendment made? This was in the backdrop of the gang rape of a woman inside a bus in Delhi in 2012, leading to her death. One of the offenders was a 17-year-old, which led to the ministry proposing the amendment. Now, the amended act distinguishes children in the age group 16 to 18 as a category which can be tried as adults if they are alleged to have committed a heinous offense and a minimum punishment of 7 years. Now, according to Section 15 of the Juvenile Justice Act, the Juvenile Justice Board is required to conduct a preliminary assessment to determine whether the child should be tried as an adult or under the juvenile justice system. Now, the JJB is composed of a judicial officer and 2 social workers. Now, they are supposed to assess the juvenile's mental and physical capacity to commit an offense, ability to understand the consequences of the offense, and the circumstances in which the juvenile allegedly committed the crime. The assessment is required to be done within 3 months from the date of first production of the child before the JJB. If the board finds that the child can be tried as an adult, the case is transferred to a designated children's court, which again decides whether the board's decision is correct. As per Section 19 of the amended Act, the court can pass a decision on whether there is a need for trial of the child as an adult or otherwise. The children's court has to ensure that the child in conflict with the law is sent to a place of safety until they reach the age of 21 years and is only then transferred to jail. The court can also order the conditional release of the child after he attains the age of 21 years. If the child is tried as an adult, the sentence can go up to life imprisonment, but if the child is tried by the board as a juvenile, the maximum sentence can only be 3 years in a special home. Now, the Supreme Court back in 2022 said that while considering a child as an adult, one should look at his or her physical maturity, cognitive abilities, and social and emotional competences. It rejected the view that if the child has the mental capacity to commit the offense, then he automatically has the capacity to understand the consequences of the offense as well. The court said the consequences mentioned in Section 15 of the Act would not be just confined to the immediate consequence, but it would also take within its ambit the consequences of which may fall upon not only the victim but also on the family of the victim, on the child, his family, and that too not only immediate consequences but also the far-reaching consequences in future. The court also said that children may be geared towards instant gratification and may not be able to understand the long-term consequences of their actions, and they are more likely to be influenced by emotion rather than reason. There was one such case where a juvenile was tried as an adult. In September 2017, a second-grade student of a prominent school in Gurgaon was found murdered inside the school washroom. Haryana police arrested a conductor of a school bus for the murder and claimed that he had confessed to the crime. However, the CBI, which took over the investigation, arrested a student of class 11th at the school for the murder. In December 2017, the JJB decided to treat the accused as an adult. In October 2018, the Punjab and Haryana High Court directed the JJB to make a fresh assessment of whether the accused should be treated as an adult or a juvenile. Both the victim's father and the CBI challenged the High Court's decision before the Supreme Court. And in November 2018, the Apex Court ordered a status quo in the case, and the petitions were dismissed on July 13, 2022. The accused has remained in an observation home since his arrest by the CBI.